Welcome back. Welcome back to our second session on piercing the corporate veil. Now, before we move forward, let's just go back to what we've covered, and I'll actually put this a little higher so you can see it. What are the factors that will lead a court to pierce the corporate veil? Now, remember, of course, that the corporate veil is this concept that shareholders enjoy limited liability. They don't enjoy limited liability in unlimited circumstances, however. It's sort of a gift, the limited liability. It's meant to improve the economy, to encourage investment, but it can create some room for some misdeeds, if you will. Sorry, I'll get my thing silent here. It can create some room for some bad action. And so we have the veil-piercing doctrine as an equitable backstop to the corporate law. So it's not in the corporate law. It's something that the courts have developed over time to try to make the situation more fair, because corporations externalize a lot of their risks onto society. Some of those risks, okay, that's fair. Some of those risks, not fair. So what are some features or factors that will lead a court to choose to pierce or not to pierce? Well, I have them up here. So our number one factor is the corporate structure of all, the general corporate governance. On one end of the ledger, one end of the balance beam are large public companies, or just public companies. Publicly traded corporations are never pierced, ever. And that sort of makes sense, because as we'll see, the other features that would exist also are not there. Just weren't sure who you were today, Courtney, so you turned your name tag around. Now, private companies could be pierced, but some private companies are actually widely held, and you don't have this conflation of ownership and control as you would in a closely held corporation, meaning just a few shareholders. And finally, I've added this to the list today as I was thinking about it. We have our situations where we have a sole shareholder. The vast majority of piercing cases involve a sole shareholder, and the remainder involve a closely held company. There's almost no piercing of private companies, and there's never piercing of public companies. So you could think of this as a factor, but really this is a limiting factor. I mean, if you have a public company, the rest of the analysis, it will add up to no piercing, at least unless this is the exceptional case that is beyond even my ability to make a hypothetical about. Which, granted, is not that great. But the next factor, the number one factor that is found, the factor that's found most often in piercing, courts are most willing to pierce when you have then a company that has the right structure and there is a misrepresentation. And this may be why we find that there is piercing in contracts more than in torts. You don't really have the chance to misrepresent that you're going to run somebody over, right? And say, oh, I promised to run you over with a truck and I only hit you with a Camry, you know? No, this is usually a misrepresentation of a contract, that the contract, we're going to pay you for 5 years, we pay you for 2. And so misrepresentation is the number one factor, and that might start us to lead to understand why piercing is more frequent in contracts cases than in torts cases, even though it's counterintuitive, since you might think that contract claimants are assuming the risk of engaging with a company. Well, they're not assuming the risk of being lied to. Next, we have commingling of assets. And this goes to the alter ego doctrine. When a company has management, or a sole shareholder more likely, that treats the company as their own personal piggy bank. This goes to the domination and control element that we see down there, but in studies, the second most common factor, aside from corporate structure, which is more of a limiting factor, but the kind of on the scale, commingling of assets will lead courts to pierce. And this may lead us to pierce in torts cases as well. So while we don't pierce as frequently, there is piercing in torts cases. And if you're treating the company as your own piggy bank and you run someone over with the cab that you own, you might pay out of your own pockets. You sort of lose the ability to separate your assets when you haven't been doing that all along. Our third factor would be undercapitalization. Not minimal capitalization, but undercapitalization, when the company does not have enough assets where it's being drained of its assets. This is not as bad as commingling assets. Commingling assets is when you treat the company like your own personal piggy bank, and you disregard even having separate bank accounts. Money that should be going to the corporation goes directly to your pocket. This is not quite as severe when you have a case of undercapitalization, but you're using the right process. You have separate accounts, but every chance you get, you're withdrawing all the money from the company, and you're really doing it intentionally in order to prevent people from having a successful suit against you. Yeah. And then our fourth most common factor, which is sort of a head scratcher, failure to observe formalities. Why does that matter? I mean, on the side of the tort claimant, honestly, the tort claimant doesn't really know or care whether or not you had an annual meeting. Right? That's not relevant. But it seems that courts are playing a little tit for tat, in that if you don't observe corporate formalities and you don't observe the rules of corporate law, courts are going to be less willing to give you the benefits of corporate law, although that is our fourth most common factor. Now, those factors are captured a bit, and I just put these down here, and maybe I could even draw kind of a dotted line a little bit, because in a sense, some of these are restatements, but we also see a couple other features, if you want to think about them, that come up in our cases. One is the idea of domination or control. And so we generally only have, this is actually part of the alter ego doctrine, as we'll see as we review that doctrine today. But domination and control is really only possible when you have a small group or one shareholder. A very large group of people who have various interests, some of which you might want to run a company to make money, right, and not as their own personal piggy bank, would not have the ability to dominate and control. Another factor that comes up is whether or not the shareholder made personal guarantees. And that's interesting because the personal guarantees themselves should give some recourse, right? And so maybe what we're seeing in those cases is those personal guarantees show that there should be recourse, and we can pierce because those guarantees, maybe they're not contractually valid, but they were promised, and they seem like misrepresentation. And finally, whether it's a tort or a contract claim is not a factor in the same kind of senses, but in general, we do find piercing more in contracts case than in torts cases. And so it really merits some consideration as to why we find piercing more commonly in contracts cases and torts cases. So it's not a factor per se, but I think it has to do with one of our factors, misrepresentation. We don't have the opportunity to misrepresent in advance of a tort. Torts are involuntary, right? Or a tortfeasor, the relationship with the tort victim is an involuntary relationship, at least on the part of the victim. Right? You're not deliberately getting your motorcycle hit by a cement truck. At least most people are not. And so you're not in a position of being misrepresented to before you get hit by that truck. Just so happens when you get hit by the truck, if the truck is owned by a company which has a sole shareholder who's been treating it like his personal piggy bank, and it's undercapitalized so it doesn't have the resources to pay you, courts will be more likely to pierce. And so whether or not it's a tort or a contract is not dispositive. It lends itself to the other factors. And this is not, by the way, a rule of law. This comes from scholarly studies that have looked at when courts pierce and done some analysis. So we'll return to that at the end as we close the section. But let's now turn to Freeman versus complex computing and talk about when courts do pierce, because we actually haven't seen piercing happen yet. So I'll leave that up there for you. And we'll start here on this side of the ledger. We have two cases where there was a claim for piercing in a contract setting. And on the one hand, we have a case where there was piercing. And on the other hand, we have a case where, although the trial court would pierce, the appellate court reversed. So this must be a case that's somewhat close to the line. Reasonable courts can disagree. So these are very good cases then to see what got us over the line here, what kept us behind the line here. So let's start by talking about Freeman versus Complex Computing Co. And quite frankly, the case is complex. So I'll go ahead and just explain the structure to you as you kind of follow along. And I think it is very helpful, by the way, in these cases to map it out the way that I've tried to do here. So what I'm doing is illustrating for you what I would suggest you do if you're presented with a question like this, because the structure really matters. So when Jason Glazier was in graduate school at Columbia University, he developed a software program that apparently was very valuable, and he wanted to license it. So a quick tidbit, if you develop software, you're a graduate student, the school usually owns it. If you develop any technology, it's actually one of the big benefits schools get from their PhD students. If you're a PhD student, you probably don't pay for your school. You might get a small stipend, whether or not you teach. You may work in a lab or produce something, but the intellectual property that you develop while you're a student is generally owned by the school. And schools have offices called technology transfer offices, which can license this technology. Now, schools rarely sell the technology. They rarely sell the patent or any of the underlying protections. They will license it. There are a number of reasons why, beyond our scope here. But in any event, Columbia University was willing to license the software back to Glazier. Well, they were willing to license the software, but they weren't willing to license it to a corporation of which Glazier was an officer, director, or shareholder. Quite frankly, I have no idea why. That doesn't make any commercial sense. What do they care? What do they care? But they care, right? So university, it's a bureaucracy. They've got rules and procedures and hoops to jump through. And so it was 1997, it was 1993, I guess, when this was developed. So maybe at that point, Columbia University was not very versed in intellectual property technology transactions, right? So they might have had some rule on the books. And so to circumvent the rule, Glazier comes up with this very clever scheme. As my professor liked to say, it was a scheme that was too clever by half. How was it too clever by half? Well, it turns out that the scheme didn't work. It was in fact a scheme, and it was too transparent. So Professor Baird would say it was too clever by half here. So what was the scheme? The scheme was that they were going to form, let's go this way here. They're going to form a company called C3, and C3 will not be owned or operated by Glazier. In fact, it was owned by a friend who's not named in the case, but a close personal friend, and it was operated by a man named Seth Akabas, who's the president. And so Glazier is not an officer, he is not a shareholder, he's not a director. So why would he be involved? Well, he had this very interesting deal. He was an independent contractor, and under this independent contractor agreement, he had an option. He was paid for work that he provided, and he had an option to purchase all the stock for $2,000. At any time, there's an unlimited option to purchase all the stock. So effectively, he was able to put himself, at his discretion, he was able to sort of substitute these positions for $2,000. So you see where we're leading with this. So we have this structure, and I guess it's good enough for Columbia to give the license, and now the company begins operating. So they have this software, very good software, and it's valuable, and so they need to sell it. So we hire Daniel Freeman, and Daniel Freeman agrees to sell and license C3's computer products for a 5-year term. And in return for his efforts, C3 will pay commissions on revenues over a 10-year period. It's a nice agreement for Freeman. It also included provisions relating to his compensation if he were to be terminated. So we have this agreement now with C3 and Freeman, and we know that Glazier is like and I should also mention that the independent contractor was actually Glazier Inc., not Glazier himself. There are all kinds of reasons one might do this. Maybe he didn't want to have liability for his work that he was providing. Maybe there was some tax benefit. Who knows? But he was the sole owner of Glazier Inc., and he did, in fact, control it. The question really comes down to whether or not he controlled C3. All right, let's see how that comes up. So in August of 1994, C3 and Thomson Investment Software entered into a licensing agreement where now Thomson is going to get exclusive sales rights. So I keep on putting my chalk down. I really should stop doing that. I'm not used to the blackboard thing. I'm having a little fun with it. All right, so Thomson now has an exclusive, which means that this is worthless. Daniel Freeman can no longer do any sales work because someone else has an exclusive right to sell and market the software. But he's still entitled to payments. He's still entitled to payments for this period of time. This is a bad deal for C3. They didn't know, 20/20 hindsight, it's a bad deal. When they were making it, they thought, great, we have Freeman. But now they've done much better than Freeman with Thomson Investment Software. And in fact, it seems like Freeman helped them get this contract with Thomson. So after this happens, 2 months later, in fact, C3 terminated the agreement with Freeman and said they're also going to stop paying him in the following way. They're going to essentially liquidate the assets. So in January 1995, Thomson hires Glazier as vice president. So this guy actually comes over. He becomes the vice president of Thomson. And Thomson and C3 entered into an asset purchase agreement. So by that, it means that Thomson is going to acquire all the assets of C3. It's very much like a merger. And so under an asset purchase agreement, it has actually a lot of advantages mergers don't have, that you don't assume generally some of the liabilities. And so they actually list all the assets and liabilities that are going to be transferred in this asset purchase. And what are those liabilities? Well, I'll tell you what they're not. They're not the contract with Freeman. Thompson is not assuming the contract with Freeman, and so in this way, Freeman, his 10-year period is up a little early. He didn't get the deal he bargained for. And at the end of the day, the money is going to flow to Glazier. So Freeman files suit against C3 for breaching its agreement and seeks recovery beyond the limited liability of C3, because at this time, C3's assets are like 10 grand. Think about some factors here. 10 grand. And they owe this guy hundreds of thousands of dollars. And they just had an asset sale. You sold all your stuff. And you have no money to pay your debts? Someone's going to be annoyed about that. So Freeman filed suit against C3 for breach and sought recovery through the shield. He sought piercing due to Glazier's domination and control over the company. The district court found that C3 and Glazier need to arbitrate this under their agreement, and it ruled that Glazier was subject to the arbitration clause of the agreement. Oh, sorry, I should have mentioned that. This licensing agreement had an arbitration clause, and I assume that Freeman thought that would benefit him. And generally, arbitration clauses often benefit a smaller party because arbitration is less expensive. And in litigation, you have these cost asymmetries. One party can simply grind the other one into dust if you have a really big party, really small party. I mean, you just don't have enough money to feed the fire, meaning pay our bills. So the question of whether or not this is going to be arbitrated might have that's a procedural question, but it might have real substantive consequences. So the district court found that they needed to arbitrate and ruled that Glazier was subject to it because he did not merely dominate and control C3, but because he held the sole economic interest of any significance. Effectively saying that this relationship, this friend, this is nothing. There was no money here. Let's put a zero. This is C3's money. Right, maybe he was entitled to $2,000, but $2,000 is not a lot of money given what we're working with here. And so the economic reality of this company was that because of this option, Glazier was able to become the owner very easily, and he acted like the owner. So, is Glazier an equitable owner of C3? Equitable ownership. Is he an equitable owner? What does the equitable ownership doctrine say? And can the corporate veil be pierced to this equitable owner? So we have two separate issues to deal with. Under New York law, the doctrine of equitable ownership applies. And the doctrine of equitable ownership states that a non-shareholder is may be the equitable owner of a corporation where the non-shareholder, quote, exercises considerable authority over the corporation to the point of completely disregarding the corporate form and acting as though its assets are his alone to manage and distribute. Unsurprisingly, that's very similar to our veil-piercing factors. Treating the company like his own, dominate, control, right? Not observing formalities, perhaps. And so we have that first doctrine. And so the appellate court holds yes. Yes, in fact, Glazier was the equitable owner of C3. He effectively owned it. He was, although the structure was different, and for whatever reason the guys at Columbia University thought this was fine, and this was somehow different from what they were trying to avoid for whatever reason. It wasn't different. This was exactly like if Glazier was the friend. Less $2,000. So he was the equitable owner. Now, does that mean we're done? Now that Glazier is the owner of C3, does that mean we pierce? No, there's more to it than that. This is where the trial court got it wrong. The trial court found that he was an equitable owner and stopped there. The appellate court reminds us that now we've determined who the owner is. Now we have to see whether or not we pierce. And under New York law, which this is tried under, to pierce the corporate veil, a plaintiff must prove three things, very similar to our other tests. One, that the owner has exercised control such that the corporation is a mere instrumentality of the owner. The owner is the real actor. The corporation does not have its own separate existence. It's simply the owner in another form. And such control was used to commit fraud or wrong, and the fraud or wrong is a proximate cause of an unjust loss or injury. So, the trial court got it wrong in two different ways. One, they didn't even apply what amounts to the alter ego doctrine, and two, they didn't understand all the elements there. There are three steps in the alter ego doctrine. One, we have the idea of domination, control. That's the alter ego part, but that domination or control must be used to do something bad. And that bad thing must be the proximate cause of harm. So here, since Glazier exercised considerable authority to the corporation, he disregarded the form and acted as if the assets were his to manage and distribute. It was appropriate to view him as its equitable owner. His obligations encompassed the entire business, and after C3 entered into the agreement with Thompson, all the taxes, all the expenses, all the salaries were paid to Glazier, and C3's bank account had only $10,000 in it. Right, look at, this is a siphon. He's siphoning off the corporate assets. Right, this is the valuable relationship, and he's taking it for himself. So clearly, equitable ownership is fine, but the element of control was not sufficient to justify veil piercing. Why? All three elements need to be met in order to pierce the corporate veil. So the circuit judge, Minor, remanded the issue to the trial court as to whether Glazier used his control to commit a fraud or wrongdoing, and whether that fraud or wrongdoing was the proximate cause of the injury to Freeman. Now, there was a dissent here, but it was kind of an unusual dissent. It was actually a dissent that was even more favorable. It went even further in that direction. Judge Godbold concurred in affirming that Glazier totally controlled C3. But he actually said remand is not necessary. What is the purpose of remand? Why do we remand things? What happens upon remand, Brett? Well, let me ask it differently. What do trial courts do that appellate courts do not do? Determine facts. They determine facts. And so remand is a fact-finding. The concurring in part, dissenting in part, Judge Godbold said, we don't need any more facts. Look at these facts. These are terrible facts for Glazier. We don't need any new facts. We can go ahead and decide this case on the record in front of us. On remand, the district court, in fact, did find that the actions were fraudulent and wrongful, and they proximately caused Freeman's harm. However, the upshot of this was that it needed to be arbitrated, okay? So it goes back to arbitration. We can assume who's going to win that one. So, in a nutshell, the C3 case brings up two things. One is the doctrine of equitable ownership, which you haven't seen before, but a person can be like a shareholder and treated as a shareholder in certain circumstances. And so the case of C3, Complex Computing Company, explains the doctrine of equitable ownership. Glazier here was an equitable owner. But it also reminds us that the alter ego doctrine, you need to meet all three elements. Right? There has to be this sort of domination control. The domination and control has to be used fraudulently, and that fraudulent usage has to be a proximate cause of harm. We need to show all three of those things in order to pierce.